Hi, this is Connecticut attorney Ryan McKeen, and today I'm here to talk to you about dog bite law. I'll never forget the time I was a paper boy growing up, and I'm riding my bike, delivering my papers, throwing my Journal Enquirers on people's porches, and a gentleman was walking his dog. And as he's walking his dog, I just remember the dog had one of those expandable leashes that was like elastic. The dog grabbed onto my ankle, punctured my jeans, threw me to the ground, latched on, and continued biting me while the owner removed him. Now that was scary, but fortunately I was okay. Other than a ripped pair of jeans and a few scrapes from falling off my bike, I was okay. Some of my clients aren't that okay. I've had clients suffer serious nerve damage as a result of this. I've had clients have severe damage to their hands, their limbs, and their faces from dog bites. So dog bites can be very serious injuries. And today I'm here to talk to you about three things. These are really the basics of dog bite law. There's a lot more, but these are the basics. The first thing I'm here to talk to you about is strict liability. And what strict liability means is it doesn't depend upon harm. Most of the time, somebody is liable for somebody for damages when they do something wrong, as in they were driving the car too fast. In a dog bite, that's not the case. You could have a good dog who's well trained, who's on a leash, and bites, and that owner is strictly liable. So it's not a good dog, bad dog thing, or it's not anything that the owner does, simply that if the owner is responsible for any time a dog bites a person for damages stemming from that bite. The second thing you need to know is that not only an owner can be liable, but a keeper can be liable. And what's a keeper? A keeper is somebody like a dog walker, somebody who has possession of the dog, but is not the owner. So a dog walker, a kennel, perhaps a vet who is in control of the dog at the time of the bite, that person can also be responsible. And that there are two exceptions to dog bite law. The first exception is trespass. Now, if a dog bites somebody during a home invasion or something of that nature, then that's an exception to the dog bite strict liability. Obviously, the dog is protecting its house and its family members and really doing its job. So nobody's going to hold the owners of the dog responsible for that. And the second, perhaps more common exception is what's known as a teasing, tormenting exception. So teasing and tormenting is, just that hitting a dog with a stick, showing a dog food, riling up a dog, those things when the dog is excited by the acts of the person who is bitten, in some way teased or tormented, then again, there's going to be no liability for the bite at that point. So that's a general overview of Connecticut dog bite law. And if you have any questions or if you've unfortunately been bitten by a dog and would like to contact me, please do. My number is 860-471-8333. And again, my name's Ryan McKeen, and I'm happy to talk to you.